Everybody, thank you for joining us today. I'm Robert Theobald, the Small Business Ombudsman and Vice President of Small Business Services. We've got an exciting boot camp session for you for this Tuesday, January 25th. Can't believe we're all towards the end of January already. It's a flying by. As we like to do, we want to start first with recognizing all of our community partners. We cannot do these boot camp sessions without our community partners, their time, their effort, and their expertise. And this list is just a small list of our community partners. We have over 140 community partners that have helped with the boot camps over the last year and a half. So for those not familiar with the Small Business Boot Camp, it is designed to help small businesses work through the COVID crisis and return stronger than ever. It is a statewide initiative supported by all of our community partners. And not only is it a webinar every Tuesday, it is a resource collective and a content library. Additionally, for 2022, we added a workshop series with our community partners. And our first one had an overwhelming success in registrations, and there's actually a waiting list for it. It's this Saturday with SCORE Greater Phoenix on the ABCs of starting a business, but they have other versions of that workshop on their calendar. If you're interested in it, you can find some different dates where they'll be hosting the same workshop, or you can go back and look at some previous sessions. We have done that workshop in a condensed version as part of the boot camp in the past as well. But what I want to do right now is I want to talk about our content library. So the content library is a result of recording all of our boot camp sessions. Since we started the boot camps in April of 2020, we've recorded over 180 sessions and have those recordings available to you on our bootcamp website. And you can go back and review the boot camps anytime you want. You can share the link for it with your friends and neighbors or other business owners that may benefit from that. It is a great tool, and there's no cost to be part of that and to view those sessions. Also, we'd like to mention a couple of the websites that are important during the COVID time is the state's COVID information and resource page, arizonatogether.org. And then the Arizona Commerce Authority set up the COVID-19 Business Resources webpage at azcommerce.com/COVID-19. And on this website, you can find additional business guidance. You can find financial information of grants, loans, and other financial programs that may benefit your business at the local, state, and federal levels, as well as other just great information that pertains to all size businesses in Arizona. Also, the ACA has a number of programs to help support small business. We have our Small Business Services, our Workforce Division, and our Arizona MEP, the Manufacturing Extension Partnership. These programs all help support small businesses throughout the state. And if you're interested in any of them, please reach out and contact myself or Faith, and we can get you the information you're looking for. Additionally, we have our small business checklist, and this is an awesome tool. It's an online interactive tool to help entrepreneurs and existing businesses identify the commonly requested licensing, registration, and compliance needs as they look to start or grow their business. And these needs are, focused on information at the local, state, and federal levels. You can also find a lot of other great business-related information on the checklist to help support you in your business growth and development. So real quick, touch on some small business updates. As I've mentioned in the past, at the end of the year, the EIDL program closed. So if you cannot apply for the economic injury disaster loans for the COVID crisis. Also, Phoenix has a small business grant. I was just speaking with the city of Phoenix yesterday about that, and they still have a lot of money available for businesses within the city of Phoenix that fit the eligibility requirements. So if you're a small business with less than 25 full-time employees in Phoenix, I would definitely take a look at the Phoenix Biz Grant. So we're going to post a link for that in the chat. Also, Maricopa County has a small business resilience program, and this program has a grant part piece, very low interest, 1% loan piece, and technical assistance is all part of this program. and it is being run by Local First Arizona and Prestamo CDFI, both great organizations and doing a great job with this Maricopa County program. And I just wanted to touch real quick on PPP loan forgiveness. We haven't talked about PPP in a bit, but if you got a PPP loan in early 2021, you'll be coming up on your date to be applying for forgiveness. So you definitely don't want to miss the opportunity to apply for forgiveness and have to start paying back that loan if you can get forgiveness for your PPP loan. In the chat, we'll post some information as well about that. And we had a boot camp a couple of months ago talking about PPP loan forgiveness. You can go back and watch that recording and get the information you need to help you apply for loan forgiveness. So with that, we want to look at some of our upcoming sessions. Next Tuesday, so starting February 1st and then February 8th, we have a two-part series on actual ideas for business owners. You can see that part one is going to be leadership, planning, and culture. Part two is focusing on marketing, productivity, and customer service. We're really looking forward to those sessions. And then we've got February 15th, marketing strategy, positioning to win with Tim Manning. This is going to be an awesome marketing piece. I've heard this presentation before, and it was so good. I was like, Tim, you got to come present on our boot camp. So we're excited to have him with us. And then on February 22nd, we have Marketing 101, start 2022 off on the right foot. And we're looking forward to that presentation as well. Got a bunch of new presenters. We're really excited about these. So please join us each Tuesday, 9 a.m. And with that, we're going to jump into today's speakers. We've got Michael Patterson, Andy Anderson, and Ryan Osugi with Spencer Fane. Gentlemen, I'm going to go ahead and turn the time over to you. I'm going to stop sharing, and they're going to present this in a panel format. So I'm going to close off my video so I don't distract you. But if you have questions, please place those in the Q&A. And with that, we'll turn the time over to the Spencer Fane team.
Hi, everyone. Mike Patterson with Andy and Ryan. And I saw already comments from Barb in Yavapai County and Dawn down in Bisbee. My family's from Douglas. And so this is glad to see we have people statewide. Spencer Fane, our firm is 400 attorneys in 22 U.S. cities and an international team. We have about 20 plus, 22 people right now at the moment in the Phoenix office. We're growing. We represent companies in all sectors, tech, but new startup companies of every kind. We do corporate transactional, intellectual property, employment, tax, disputes, etc. We had to limit our topic today to these 4 topics on starting your business, but hopefully we'll have a word at the end about intellectual property and can come back and do it better on that. We have our 4 topics for today are selecting the right type of entity for you, talking about founders' roles and responsibilities and documenting those, complying with securities laws, even though it sounds complicated, for a small business, there's issues there. And then lastly, properly structuring a plan for executive or employee compensation, doing it right up front. First topic, selecting the right kind of entity for you. Andy, I'll just jump in, but then Andy will be kind of moderating this topic. Where to incorporate? There's 2 components to this. What kind of entity, and then where do I incorporate? The biggest question sometimes we get asked about Nevada and Wyoming, but most people are looking at either Delaware or Arizona who are in a call like this with you. Should we do Arizona? Should we do Delaware? The Delaware issue, really more of an issue of are you planning to raise capital from like venture capital firms or go public very quickly, do something on the finance and capital raising side very, very quickly, then probably Delaware, and a Delaware C Corporation would probably be in your future because a lot of the investment and venture capital people that are out there have a preference to Delaware and C Corp type of documents. However, nationally, the overwhelming, in the last decade, most type of entities that are formed every day are limited liability companies because they are so flexible. They can be elected for a tax perspective to be treated as a corporation, or as a pass-through, or as a holding company. There's a lot that can be, they have total flexibility for tax treatment. However, again, as I say, the real distinction would be, do you have a lot of capital raising in your immediate future? Are you going out to raise? Then we would probably be talking to you about Delaware. Let's say you did form somewhere else like Delaware, then you would file as, in addition, as a foreign entity in Arizona, where you're doing business, and other states as well. Every state has a distinct state law doing business definition. What constitutes doing business? And if you just have one remote worker, no office, no warehouse, no presence in Pennsylvania, but you've got one worker there, consult with your accountants and attorneys on whether you should file there as a foreign entity. Delaware has issues with annual taxes based on authorized and issued shares. Just a caution, if you do choose a Delaware entity, the fees can be expensive. If you say, I want 100 million shares authorized to write shares and issue shares in the future, we recommend you start very small and with a very small, what we call par value, to just keep you low on the Delaware radar in terms of fees until you get to the point where you need it. And you can always amend very quickly in a year from now if something is coming up. Andy wanted me to just discuss some formality issues versus running a corporation versus an LLC. If you do choose the corporation route, there are a number of things you need to do for like annual shareholders meetings. And particularly if you are become a public company in the future, you have to give notices with the appropriate amount of dates. The directors need to set record dates and then get a list of people that own your stock through a brokerage firm, et cetera. But I know that may not apply to a lot of people, but I also put together scripts for my clients so that we run that annual meeting correctly, and that we don't have any missteps that could cause a potential shareholder claim. Again, LLC is very flexible. Andy, I'm going to switch to you because go for it, man.
Yeah, thanks, Mike. I'm Andy Anderson, partner at Spencer Fane in Phoenix. There's some good conversation going on in the chat right now, so thanks to everyone for participating in that. Before I switch topics, let me go through it. Great questions. What are the implications of filing a C Corp in Delaware but functioning, living, and starting up an AZ? Yeah, that happens a lot. Mike, you addressed that briefly with a foreign filing in Arizona. Do you have any other thoughts or advice, or just overall just observations about clients that form in Delaware and that operate in Arizona?
Many times there's not a huge difference. It will show up in the header to your contracts that XYZ, Inc., a Delaware corporation, operating in Arizona, et cetera, their principal office, and ABC Company, a Wyoming corporation, enter this contract together. In terms of third parties, it may not make a lot of difference. And feel back and forth. You just need to be in compliant that if you are doing business in a jurisdiction where it's not your home jurisdiction, that you need to register in all those states as a foreign entity. The tax authority will be looking for something from you each year. So you
Right.
need to just be in compliance.
Yeah, that's great. Yeah, thanks. And then the follow-up question was, can you move the tech startup later to Delaware? Yes, you can. We have an Arizona Entity Restructuring Act, and Delaware has got similar statutes where you can domesticate. There's a transaction called domestication where you can change jurisdictions. And I do see a couple other questions on liability. Ryan has that teed up in his thoughts for you in just a little bit. Okay, so Mike mentioned choice of entity, and then just drilled down on where to incorporate. I'm going to get into a little bit more of the nuts and bolts of what type of entity to choose. I mean, there's the whole alphabet soup of LLCs, LLPs, LPs, S Corps, C Corps. I mean, there's a lot of technical jargon around choice of entity. But really it just boils down to a few real basic considerations. And one of them is going to be tax. Tax always enters into the picture where people want to know what are the right strategies to minimize my tax liability. The other main bucket of category or thought for entrepreneurs is, how am I going to manage the company? So tax and management are kind of the two drivers to guide you through which of these entity types will you be selecting. So one practical just threshold issue is going to be who owns the company. And some of these entities have different ownership requirements. Like S Corps are limited to 100 stockholders. So if you anticipate having more than 100, you won't be eligible for that type of entity. A partnership, of course, by definition, needs 2 or more people to be partners. So if you're a sole member, then that'll narrow down what choice of entity you'll have. And there's also basic differences on what the equity itself in the company looks and feels like and what it does. In an S corporation, you can only have one class of stock, meaning that everyone gets treated the same economically. But for an LLC, like Mike touched on, you can have a lot of different custom provisions that treat people differently. And then, of course, in a limited partnership, you have a general partner that's responsible for management and limited partners that are just the investors. So depending on who all is involved in your company and who's going to be owning it, that will help you decide on the front end what type of entity to form. I also want to briefly mention, just as an aside, there's a thing out there called the qualified small business stock. And what that does, it's a really amazing program where if you qualify, you can have capital gain exclusion of 100% on the sale. So a lot of you, when you sell the company, it could be tax-free. But to do that, you need to be a C corporation. And if you start out as an LLC and convert to a C corporation, there's some real technical issues and pitfalls. You might not meet the original issuance requirement for qualified small business stock. So you might be missing out on that tax benefit if you decide to start with an LLC, find out that you want to do the qualified small business stock and then want to change to a C Corp later. So if that's your goal going in, you might want to be a C Corp right from the beginning. Let me talk about 2 other things, tax, which I mentioned, and distributions. Real important thing for folks in selecting a C corporation, just be aware that there's double taxation. You might have heard of that before. It's very infamous. You get taxed both at the company level when the company earns $1, and then when you distribute it to yourself as a shareholder, you also get taxed again personally. Whereas the other types of entities that we're talking about today, S Corps, LLCs, and partnerships, those are all what we call pass-through entities. So the owners just get taxed up at their personal level on their taxes. Distributions are one other key difference between these entities. In both a C corporation and an S corporation, you have to make distributions proportionately to the ownership. So if Mike, Ryan, and I had a C Corp and we were making distributions, then however many shares say we each had a third of the shares, then we would have to distribute a third of the interim or other distribution to Mike, a third goes to Andy, a third goes to Ryan. Now, if we were holding different amounts of shares, of course, like if Mike held 80 shares, I held 10, Ryan held 10, then 80% of the distribution would go to Mike, 10 to me, 10 to Ryan. Whereas in an LLC, we can set up an operating agreement that said, Andy's doing quite a bit of the work. And so even though I own 10 units, Andy will get a return on investment, IRR of 20% before anything goes to Mike or Ryan. We can do really creative stuff like that. And one other thing that I wanted to mention, I spent some time on the drafting committee of the new Arizona LLC Act, and one thing that's in that statute that people might not realize, it's in Title 29 and 3404. If you don't have an operating agreement with an Arizona LLC, the default rule in the statute, so the one that gets applied to you, if you do not have an operating agreement, is that all the distributions are going to be in equal shares among the members. And people might be surprised to learn that if someone put in all the money or nearly all the money, they might be expecting to get more of the distribution. But if you don't have an operating agreement, then the default rule again is that it'll be split equal shares. So again, Mike, Andy, Ryan have an Arizona LLC with no operating agreement. Even if Mike puts in all the money, Mike, Andy, and Ryan are each going to get a third of the distribution. And that's surprising to people at some points.
Andy, can I make a comment on that?
Sure.
Another piece that people also forget is without that operating agreement, everybody has an equal say in the business. And I ran into a business that didn't have an operating agreement, and one of the partners was no longer friendly with the rest of the partnership team and was impeding a lot of business function and growth. And he wouldn't sign anything to get out too. So he's making it really, really difficult by not having that operating agreement.
And Robert,
Yeah.
I could just add too, as your business grows, you're going to have relationships with third parties like banks and lenders and people like that. And all these people are going to want to see your operating agreement. So if you didn't do it, you're going to have to create one at some point. And it's probably going to be harder to negotiate amongst your partners if you do it later rather than today.
Yeah, and to follow up on that, Robert, we tried to fix that issue, the governance issue in the new Arizona LLC Act. The default rule now in Section 407, well, if you're a member managed company, and we could talk about that a little bit too, is that there are certain decisions that need to be made by a majority in interest, is the new word, majority in interest of the members. We define that as essentially what right to distributions or what right to the profits those members would have. So if we thought there was going to be 80, 10, 10 between us, Mike, Andy, Ryan, the governance as far as majority and interest would be 80, 10, 10. So the old LLC Act had that one member, one vote rule. We did change that. So hopefully that helps folks in the future. Ryan, let me hand it to you for a few of these topics on choice of entity.
Sure, thanks, Andy. So I've seen a question already pop up in the chat, and we'll sort of deal with it here about the founder's liability and the assumption that a person in an LLC or a member in an LLC cannot be sued. And I will say that for S Corps and C Corps, as well as LLCs, generally the equity holders are shielded from the liabilities of the company. But to address that specific concern, it is not true that there is a complete shield. If there is a situation where someone can, quote unquote, pierce the corporate veil because they're commingling things like personal assets with company assets and treating it like a bank account. I've been in a lot of situations where this comes up because as a small business owner, sometimes keeping the books clean or borrowing from yourself can be a temptation or something. if there is a commingling of assets that allows for piercing the corporate veil, then yes, a person, a founder, an equity holder of these types of entities can actually be sued. But generally, the idea behind the founder's liability is that unless the certificate of incorporation or formation says otherwise, or the operating agreement says otherwise, the equity holders are shielded from the liabilities of the company. This is different from a limited partnership. A limited partnership involves, as Andy said, general partners and limited partners. And limited partners typically do not have the ability to act on behalf of the company. So general partners jointly and severally share liability in these types of entities. But the limited partners also can in specific situations. And it's important to know if you are a limited partner in name, but not in actual function, as in you give yourself the title of limited partner to avoid personal liability, but you actually act as a general partner, you will actually be able to be held in certain circumstances as personally liable. So it's if you're looking for maximum protection in these types of entity choices when you're picking the type of entity, then LLCs and S Corps and C Corps are generally the most favorable. Partnerships, obviously, you are going to be liable. Going along that sort of line of thinking, there are fiduciary duties that are going to be owed by the people that run the company. In this case, let's say you're in a corporation, the directors and the actual officers of the company, as opposed to the shareholders, run the business. So they will have fiduciary duties. And a quick background on fiduciary duties, there's the duty of care is a traditional duty, which means you have to be fully and adequately informed and act with care in making decisions and acting for the company. Pretty straightforward. It doesn't say that you can't make bad decisions or decisions that turn out bad. You just have to have sufficient information to be able to act reasonably. The duty of loyalty is pretty straightforward. You basically cannot act in a self-interested manner. So if you are running these companies as a director, as an officer, as a manager, you are going to be bound by these fiduciary duties, and you need to make sure that when you are acting, you are not risking breaching your fiduciary duties, because that could result in personal liability, not as an equity holder, but as a manager, director, or officer. So one way to sort of carve those out is in the operating agreement of an LLC. There are situations where you can disclaim the duty of care, not always the duty of loyalty, but you can go into the operating agreement and say, hey, we are not wanting to have liability for the breach of duty of care. Basically, the two founders trust each other to make reasonable decisions, and they come to an agreement that they're not going to apply that. It has to be a specific writing. You have to go into it fully knowingly that you're getting rid of that duty. Otherwise, it won't really be enforceable. And this is jurisdiction dependent. That is different from a corporation where you typically cannot disclaim these types of fiduciary duties. And for each type of entity, you cannot get rid of that duty of loyalty, which makes sense. You don't want someone who can go and self-deal because of a term that you have in your governing documents, and then they're giving themselves discounts or taking money or favorable loans. That's just not something you ever want to be able to get rid of. So when you're picking your types of entities, you want to look at these fiduciary duties and make sure you have some sort of understanding of what decisions you're going to be making with this company and how they can come back and give you actual liability. The only real ways to limit that type of liability is using exculpatory language, like we mentioned, where it carves out of the operating agreement, or you can get into an agreement with the company that the company will indemnify you as a director, officer, or manager for monetary damages. You won't be free from the claim, but the company can indemnify you in certain circumstances. So these are like, I guess the best way to describe them is they're big, scary situations. They're one of the few areas that you can actually get into personal liability in these types of entities, but they're pretty easy to avoid. Those duties of loyalty and duties of care are not incredibly difficult to comply with. You have to be acting in good faith. You have to be acting with reasonable information, and you can't be going behind people's backs. That's the very basic baseline. And you want to be sure that if there is anything like a breach of duty of loyalty that you're wondering about, like you're wanting to hire a family member to do something, disclosing it to the other people in the business and having it ratified is one of the ways that you can possibly get around that. So it's something that should always be in the back of your head when you're acting on behalf of the company on these fronts. So I guess we could sort of go to the next major section, which deals with this. It's clearly agreeing on and properly documenting the founder's roles and responsibilities. And the best way that we've found to do this is through the governing documents. They're basic documents, and in the case of a corporation, it is a shareholders agreement or stockholders agreement, or an operating agreement for an LLC, or a partnership agreement. And notably, these are not documents that have to be filed with the Arizona Corporation Commission or Secretary of State or anything like that. They are simply internal governing documents that is you setting up the rules for how the company works with a statutory baseline that Andy is more of an expert on than me, but those baseline rules are going to come into play if your operating agreement does not include specific terms. So in a shareholders agreement for a corporation, it's typically an agreement obviously between shareholders and approved by the corporation. And there's usually a mandatory joinder requirement, meaning that when you add additional stockholders in the future, they have to sign on to this shareholders agreement. And that's important because it keeps everybody on the same page as far as requirements and doesn't create different rules for people. Even though the stockholders agreement or shareholders agreement can change over time, you want to make sure everybody's on the same page because avoiding business disputes is a way to save a lot of attorney's fees, frankly, or limiting them at least. But stockholders agreements typically include terms like registration rights. This is a right that you as a shareholder will have when either you demand to have your shares registered with the SEC or the company registers with the SEC. You want to make sure that you have those so that you can actually have value with your shares when that happens. These types of agreements also have voting terms and restrictions, which includes classes of voting stock, the board composition, what their powers are, how they get appointed, how they get removed. That's very important as well. Preemptive rights to purchase shares, like say the company issues double the amount of shares because they're planning on raising equity. You could have a preemptive right to purchase your pro rata amount of those shares at a certain price, which is something, if you want to avoid your interest getting diluted, is something you want in these governing documents. And these ideas that I'm not pointing to every single term that can end up in this agreement, these are some of the more important ones that you just want to consider that's specific to your situation, because there's a ton of stockholders forms and operating agreement forms that you can find out on the internet. But the most important thing you can do is tailor it to your relationships and your specific circumstances, because that's how you protect yourself in your specific business. So you can either consult an attorney to make sure that tailoring is happening, or you can just go very painstakingly through the process and make sure that you're comfortable with how all of these types of terms work. And one more that is important in these agreements is the transfer restrictions. Very important, because you need to be able to control in this governing document when a shareholder can sell shares and how. So that type of thing can change as well. And making sure everybody's on the same page and can't dump shares or acquire more shares without notice or specific requirements is very important. I guess switching over to the LLC side, which is more common, the LLC operating agreement is a much more flexible document. It's easily changed, easily amended. It does things like sets the management of the company. And Andy mentioned it earlier. I guess we probably should cover that in a little more detail, but there's two types of management for LLCs. It's manager managed, which means the members or the equity holders of the company appoint a manager or managers to run the company, and they have the executory power, and the members do not. Or member managed, which means that each member can act as a manager. So in the case of a member managed entity, the members will owe fiduciary duties to the company and to the other members under the act in Arizona. But if there's a manager that's appointed that is not all of the members, if it's manager managed, that manager is the one that has the fiduciary duties, not the members, because the members are not acting on behalf of the company on that front. All they do is hold the equity. So that's an important thing to clarify between the two types of entities.
Yeah, interesting one on that. There was an Arizona, real important Arizona appellate case a year or two ago called Sky Harbor that talked about fiduciary duties under the old LLC Act. And that's right on point as far as managers owe the fiduciary duties. But beware, if you're a member in a manager managed LLC and you do act on behalf of the company, then you will owe fiduciary duties. And a lot of times that's a gap in the operating agreement because the fiduciary duty waiver will only apply to the managers. So,
yeah, that's a good point. It goes along with the situation I mentioned earlier with the limited partner, general partner. If you're basically acting as the manager of the company, you're going to be held liable for it, and that's to protect everyone else. And that seems pretty equitable, and that's why it's codified that way. So terms that you typically see in operating agreements and that we think you should take a specific look at include transfer restrictions, like we talked about before, voting terms, which includes identifying specific You can do thresholds for what requires a vote. You can do specific actions that require a vote of the managers or the members. One example would be selling all of the assets of the company. Say someone wants to come and buy. You might want unanimous consent for that, or you need a certain threshold of dollar amounts for decisions that are made. If there's going to be a spend of over $50,000, you want unanimous consent. This is the type of term that isn't statutory, but you can put in your governing document to protect yourself. There's also distribution and allocation language, which I've seen brought up in the chat a little bit, which is distribution of the assets of the company. It can include profits, but it can also go beyond profits in certain situations for accounting purposes. And that's something that typically is worked out. You should work out with your attorney and your accountant to make sure that the distribution and allocation language is not only financially efficient, but also legal and not going against the general principles of these types of entities. And most notably, and this is something I mentioned for corporations as well, buy-sell terms, or when you can transfer shares between members. Sometimes this arises in situations like one of the members' deaths or incapacitation, an unresolvable business dispute, when a member is an employee and ceases to be employed because they're terminated or they resign, or member withdrawal if it's even permitted. So having specific buy-sell terms that say when a person has to have their shares bought or sold and who it can go to is incredibly important, because that's how you guys retain full control of the company in a predictable and an efficient way. So that is something that should appear in most operating agreements, in our opinion, and it's something that a lot of those basic forms kind of miss on, or they oversimplify, and we can touch on a little bit more later if we have time. The last thing to note with operating agreements is that there's typically a schedule at the end that sets forth the membership interests. We typically use membership units. So there's a certain number of units issued by the company to the members. Say there's 100,000, each member has 50,000. That equates to a 50% percentage interest. And that's typically, or can be, how voting works or how distributions work, unless you come up with alternate terms. So
Right.
the operating agreement goes along with the partnership agreement to a large degree. There's some statutory changes or some other requirements, but generally all of these documents have some sort of boilerplate terms: tax treatment, office in Arizona, availability of records that you'll find everywhere. But the ones that I highlighted above are kind of the ones that you want to have working in the back of your head when you're thinking about how to protect yourself and how you want to formalize the roles of the individuals in the company. So just to touch on some brief points, if I have another minute or so, it's important to note that you need to formalize the relationships between the company's founders and avoid acting through casual business relationships. Mike mentioned this earlier, but when you're in these early phases, it's tempting to just go off of like emails or oral discussions, even between founders, about what's expected of them. It's a best practice to get everything in writing and fully delineated, whether it's the company's founders agreeing to work for the company as a condition of holding equity, whether it's hiring someone's cousin to do the website for $1,500. The numbers may seem small, but when you're coming down to protecting your equity, if you're ever going to raise money or sell the company, you want to be able to have these contracts locked in so that there can't be any confusion or any gaps. Setting out and writing the founders' roles and responsibilities. Some founders want to have day-to-day control, others don't. Defining that in your governing document is very important. And you can even consider whether compensation is involved. Typically, I don't think we advise doing compensation for typical manager day-to-day operations, but that's something you should look into if you're interested in it. Recording your ownership percentages among the founders and other owners. Having a document that's updated and correct at all times is incredibly important, because you need to be able to update the Arizona Corporation Commission or your Secretary of State. And if you ever do a sale of stock or a fundraise, that document's going to be incredibly important, and you don't want to be guessing about who owns what and where. And I'll skip sort of to the end and say, like, one of the bigger issues that people run into when they have an incomplete or a gap in their operating agreement is how a founder exits from the business. There is not an automatic right to withdraw from an LLC in Arizona. Typically, there needs to be unanimous consent of the members for that to work. It's not necessarily intuitive, but if you think about it, you don't want people bailing at will. So defining the exit steps is going to be important, whether it's the leaving owner having to sell at a certain price or things like that, whether a restrictive covenant applies. Restrictive covenants are non-competes. which you've probably heard of and nobody likes, frankly. But if you're protecting the value of your business and you want to stop your business partner from taking everything like employees, soliciting employees, confidential information, that is something you would include in your governing documents as well. So these are the types of big picture issues that are not covered in the basic operating agreements you'll see most likely, and hopefully it can get you thinking about where you need to protect yourself for your specific business and how to go forward. So I think Mike's up next for his section, and I'll turn it over to him now, but we can also take questions in the Q&A.
Yeah, there's a lot of good activity going on in that question and answer. Any drawbacks to starting an LLC and then switching? That's one question. I mentioned the qualified small business stock. That might be something to think about. When you say distribution, do you mean revenue or profit? Profit, both interim and then if you're selling liquidation. Mike, what if you're an international person? If you're a visa holder starting a tech company in Arizona, why don't you take that one and lead us into the security stuff?
Thanks. And I would say in answer to that one, a person who's not a U.S. citizen and who does not have a work visa here in the United States is not allowed to. There are certain kinds of entities that won't work, like an S corporation is not available to you. However, LLCs are very flexible. You can have all foreign owners in an LLC. Yes, you would consider that. Also, Ryan and I do a fair amount of international inbound companies, and where it's going to be important for that F1 person, think ahead. Does he or she need to be in Arizona physically a year from now? And think about when that F visa ends, and do you need to move to other kinds of visa, like an E-class visa or an investor visa, or do you need to move to transfer personnel visa from wherever they're from, having a parent and transfer personnel? There's strategies that can be done right now to set you up for in the future, so there's a better immigration strategy. But we don't have time to talk about that today. I did want to say, getting out that Ryan mentioned, there's no, as he mentioned, there's no statutory basis to get out, of an LLC or stock, other than is provided in the governing documents of the entity. But I mean, at law, you're putting in equity, and it's at risk, and it's there unless someone offers to buy you out, or unless there is a way to get out under the operating agreements. That's different from a loan where, let's say your mom or dad gives you, $100,000 to, as a loan to the business, and it's going to be repaid back under a promissory note. But even certain types of debt, if you're doing convertible promissory notes to a group of people, those are going to be securities, as we're about to talk about in a moment. I did want to say one other thing to recap something from our first section. Ryan was talking about great things about limited liability, which is the whole key here, and preserving that and not giving foot for someone to pierce that corporate veil. Be smart. Don't pay your kids' tuition out of the company bank account. Give yourself a salary or a distribution, put it in your own bank account, and then pay the tuition or pay the vacation or pay the car payment or whatever it is. Don't pay your personal expenses directly out of the company. The second thing is just a simple thing: disclose the entity and your role. If you are Don Smith and you have Don Smith Consulting LLC, the entity, the legal person is Don Smith Consulting LLC, not Don Smith. And down in the signature block, you put Don Smith Consulting LLC, and then you have a signature line by, and then underneath Don Smith, manager. In other words, who is signing that document? Not Don Smith. Don Smith Consulting is signing that document through the manager who has the authority down below. So when you form an entity with your attorney or on your own, make sure you sign the documents right, that it's not you, it's that entity. Protect your personal liability. Okay, let's talk about securities. boy, this seems like this is too big a topic for startups of, at this level. Well, not really, okay? Because anybody who puts money into your business, including you, is actually purchasing a security in the business. Even as if you have a pooling of obviously stocks and bonds, those kinds of things, you expect those are securities, and they are under federal securities laws. But investment contract is listed in the securities laws, and that means where you pool money together with other people, you expect a rate of return, plus it's primarily from the efforts of others. So anybody who's passive, even your brother-in-law, even your Uncle Sam, is your Uncle Sally, excuse me, who puts money in your business. There is no friends and family exemption from securities in the securities laws. People say the friend and family's around. Well, people normally go get money from their friends and family, but there's no securities law for that. What there is an exemption for is a private offering of securities, and that's what people are doing normally at this first level, is a private offering. And it's in the securities laws under something called 4A2. However, there was a safe harbor created decades ago called Regulation D, in which it defines some terms that you might have heard of: accredited investors, people who have a certain amount of net worth, million, and they make this certain amount of money per year, or with their spouse, this amount of money, they're accredited. And if you're going to do an offering of a big amount, you want to get an exemption. You don't want to go raising money unless you get an exemption, and the offering needs to be exempt. The offering itself as a private offering, but also the offerors need to be exempt too. In other words, normally in a securities offering, the offerors would have to be FINRA licensed through the Financial Regulatory Association nationally. But and we don't want unlicensed finders, some guy named Bob with a Rolodex raising you money out there. That's not permitted under securities laws, okay? And we'll get into that, another day. A lot of things there. But my point being is, if you're out there raising money, even from friends and family, you may want to talk to someone and make sure that you've got it covered for securities and exemption, the securities exemption. And by the way, a securities claim, I say, is the F word. It's securities fraud. So I've even seen a brother-in-law sue their sister-in-law to get their money back because they want out, and there's no out. The documents didn't give him a way to get out. So what does he do? Well, he was a passive investor. So what does he do? He threatens a claim for securities fraud. And fraud will ruin your whole day. It will, if you have that, you may have to report that for the rest of your life and not be able to get a real estate license, not be able to get an insurance license, not be able to, you may have to report that. So it is a concern, okay? So in the area of securities laws, this is a topic that has a great deal of detail for another day, but let me give it back let's see, I'm just looking at one comment here about I'm not, it's just me and I'm in an LLC and I'm an officer right now, not pulling money out, not earning revenue, I'm funding it personally. Still, observe the corporate formalities. Have your corporate account, have your personal account, pay yourself a salary, have your accountant work with you to move that money to your personal level. Then it's yours. You can do whatever you want with it at that point, but don't be paying your personal expenses out of the corporate account.
Right. Okay? Or if there's no revenue, not earning any revenue, no sales, if you take money out, I mean, that could just be a return of your capital contribution. So it's not going to be problematic as long as you record those transactions properly.
By the way, document a promissory note. I put in $100,000 to my company, or 10,000, and just document a promissory note that the company owes me that money and it's earning this much. It's very, very common. We're working with clients who, they said, I've put in, over the last 10 years, I put in $600,000. Oh, and how many tranches? This many. And did you ever document anything there? No, not really, but the bank statements show the dates, and so we may go clean that up at some point. Okay. I'm going to turn this back over to Andy for how to structure executive compensation in the beginning, and then I'll have one word at the end about protecting your IP real quick, and then we'll talk. Robert asked me to talk about that, and then we'll talk about that bigger a different day.
Sounds good. Again, thank you, everyone. We're so grateful for you being here today and for you participating, and everyone's engaged and there's thoughtful discussion back and forth, and not only with us, but between you. One comment I really like, dream big. I love that. So thanks for sharing. And lots of other good questions in here too. And I want to clear up that Mike's illustration of Bob with the Rolodex is not referring to Robert with the ACA. He's going to have to apologize for using your name, Robert. So, okay, equity compensation, or how do you, or what are the different ways that we see companies issue equity to founders, and then also to employees or people, talent that you're trying to attract, people that you need to help you, but you don't have the cash to pay them. So a lot of times people will instead offer maybe a smaller salary or a smaller amount of cash, but then offer a share of stock, some equity in the company. So there's a lot of technical accounting, tax, legal requirements for issuing equity and equity compensation specifically, but I'll try to make it as simple as possible. Essentially, the things that you're thinking about are, do I want to give stock? Do I want to give cash? Do I want to give the ability, the option to purchase stock? So those are a few different tools. And then drilling down further from there, once you decide I want to give stock, then you've got a question to ask, do I want to give it now or later? And so that has to do with vesting of those shares. But really, all of those technical jargon really just has to do with those basic concepts, or am I giving cash or stock, or the option to purchase stock? And do I want to give it now or later? Those are really the things that you need to think about. And then depending on how you come down or what your desires are for that, you have different tax consequences, because when you receive something now, whether it's cash or stock, the IRS wants its revenue, its tax revenue from that value, from that compensation. So a lot of our strategies around how we choose either restricted stock, stock options, or restricted stock units is going to be centered on who wants to pay the taxes and when, and what's the value of the company now. And is it a problem if we give someone shares today? Because if those shares have a lot of value, say your company is worth $5-10 million, if I hand one of your employees just outright some shares of that stock, they have to pay taxes on it. So you have $1 million company and you give away stock equal to 10% of it, then that person has a tax bill for, they just earned essentially $100,000 in ordinary income. So just rough numbers. I mean, maybe they have to pay the IRS $40,000 when you just handed them stock worth 100, but you didn't give them any cash. So maybe they need to come out of pocket to pay that tax bill. So that's some of the major themes around what we're trying to structure for, and what sort of tools we want to use is just not to create any surprises or any tax burdens that you don't anticipate or want on the company or the recipient, the grantee of the equity. And there's a lot of things to consider as far as stock options too. You can grant special incentive stock options that have some special favorable tax treatment to employees, but you can't give those to non-employees like contractors. So there's some rules that we navigate there as well. That's my crash course in equity compensation. There's a whole lot behind that, but really, again, just think about, do I want to give cash, stock, or the option to purchase stock? All of those are separate and distinct things. And then do I want to give it now or later? And then just being mindful that there's tax consequences that accompany those choices. Mike, we've got about 5 minutes left on the clock. Why don't you touch on IP for a minute or two?
Okay, real quick, your name for the business, okay? It might seem like a small deal that, I mean, in Arizona, the name was available when I got it from the Arizona Corporation Commission. The Arizona Corporation Commission will only check a direct hit. So if there's no direct hit to another name that is out there, and you might even find that there's 10 names very close to your name if you actually do a search before you pick that name. And I would encourage you, go for a strong mark, stay away from confusion with others. But that's just the Arizona Corporation Commission, where people will say to us, well, I got the domain name from GoDaddy.com. Well, that doesn't mean you have rights to that name. That means GoDaddy didn't have a direct hit of someone else that wanted that exact name. The place to go where if you want to have rights to your name is the U.S. Patent and Trademark Office. And you may want to try a search there, uspto.com, and you can even do it yourself. Look for some searches, but it's each of the three of us are lawyers, and yet we still depend on our trademark lawyers to do a better search, because for some reason I searched there, I don't see anything, and my trademark guy or gal finds something that is listed a different way. They search for it a little bit differently. It's really important to get that name right at the beginning, because you're going to pour a lot of goodwill into the bucket of your name over the years. And it would be just devastating if someone a year from now wrote you a letter and said, stop using the name Smith Veterinary LLC. That's our name. We have a registered trade name, cease and desist right now. And for you to change at that point, when all your clients know you, that'd be tough. Another thing is patents as well. If you have technology that you're patenting and you're talking about it to customers, you're using it in commerce, or you're out there raising capital from people to invest in this company that has this technology, and you're telling them about it, the clock is running. You may only have a year from a certain date where you started talking about it or commercializing to get that patent filed, or you may lose it forever. And so it's really important, timing wise, right up front. People are not aware that their clock is ticking on their intellectual property. Also, with employees, get appropriate agreements that they're gonna the things they create and think up while they're working at your business are works for hire, and you own it. And then agreements with third parties, consulting, suppliers, etc. The intellectual property that's being used belongs to you. Those kinds of things early on in your business, really important.
Yeah, that's good. And we've got a bunch of other questions. Sorry that we can't get to all of them today. I know that Mike put our email addresses in the chat. Is there a difference in tax reporting in a single member LLC? Yes, single member LLCs could be disregarded entities for tax purposes, not for liability purposes, but for tax purposes. And you may be putting all those tax items on your own personal Schedule C of your personal tax return.
Thank you, Robert.
Yeah, back to you.
Excellent. Thank you for the great presentation and sharing that information. A lot of great tidbits that many of us probably weren't thinking about as we look at starting businesses. So we appreciate it very much. And we'll definitely have you back on to dive deeper at some point on the IP and trademarks and trade names and protecting your businesses that way. But again, thank you very much. We appreciate all of our attendees for being here with us. And we hope you join us next Tuesday. Until then, we'll go ahead and wrap up. And again, we want to thank Mike, Andy, and Ryan from Spencer Fane and for joining us and sharing their expertise with us. So thank you, gentlemen. Everybody have a great day, and we'll talk to you soon. Bye.